Ndị be anyị ekenekwanụ m unu ọzọ n'ụbọchị uhuruchi nke tata. Asị m unu daalụ nne na ụmụ ife ka unu si wee na-esore anyị na-eme n'iru akwụkwọ na Eastern News 24. Anyị sịkwa ka nkọ echiri ya zero. Anyị sịkwa ndị be anyị na ọya dịrị unu na mma na eke, na ọya dịrị unu na mma na orie, dịrị unu na mma na afọ, ọzịrị unu na mma na nkwọ. Ụzọ ahịa nọ nke ndị Igbo jibiri na ọya dịrị unu na mma na unu ya dịka echi na echi ada agwụ agwụ. Otu anyị kwuru otu akọ ya dịrịrị. Ise ise ise. Dịka o si dị ncheta oge gara aga, dịka anyị sikwa unu nkwa na gị na-enye unu daily update. Ọ gbasịta maka ihe eme n'obodo a, ana gbasịta maka nwere ụwa na-azọ. Ya bụ ife wetara unu bụ ihe dị mkpa, nnukwu mkpa, na onye ọbụla bụ nwaafọ Igbo ya ga ya bụ ife. Ọbụna ịbụ onye Igbo na-anụ unu, gbaa mbọ ka ị ga this thing. Ị ga-esi ya from the beginning, site n'isi ga-esi ya nche niile ka ọgwụ. Mma like ka onye ọbụla kwuo uche ya gbasịta maka ihe ndị ọ jọrọ ijere ugbu a. Chọrọ m ịka mmọnwụ n'elu mmọnwụ. Mma agba nkịtị kwunu ga ya bụ ife unu nke sizie ya ọ na drop oyi unu jelu, and I ka ga-ekwu okwu gbasịta maka ya. Alright, over to you, sir.
A very good evening to you. Welcome to Urban Prime Time here on Urban Radio 94.5. Glad to have you on the program, a place where we get to bring critical social-political issues to the front burner. And today wouldn't definitely be an exception, the 20th day in the month of March 2024. My name is Favor, and thank you for joining me this beautiful Wednesday evening. Now, on the front burner is the issue regarding the leader of the indigenous people of Biafra. If you have followed up keenly on his case, there was a bail application, but of course the Federal High Court on yesterday dismissed the fresh bail application that was filed by Nnamdi Kanu. Now the judge, Binta Nyako, in a ruling held that she cannot reverse herself, having earlier rejected the first bail application, but then he said the only option available at this time was for him to lodge an appeal at the Court of Appeal. However, she also said that the case would have to the case would have to be accelerated. There would have to be some level of accelerated hearing so that we can get over and done with this case. But then, in order for us to really get more clarity as to what happened, and on that day yesterday, Mazi Nnamdi Kanu got the opportunity to speak to the press. He talked about quite a couple of things: his health conditions, the insecurity in the southeastern part of Nigeria. But today we want to catch up with counsel to Nnamdi Kanu in the person of Barrister Aloy Ejimako, who was in court with him yesterday, so we can really get updates as to what played out in court yesterday. Thank you for joining me on today's edition of Urban Prime Time, and introducing my guest for this evening, who joins us virtually, Barrister Aloy Ejimako, counsel to Nnamdi Kanu. Good evening to you, sir. Thank you for joining us.
It's my pleasure.
Thank you for joining us. All right, so yesterday, I guess, must have been a very busy day for you.
Yes.
The judgment delivered by Justice Binta Nyako, did you anticipate it?
No, we didn't, because we had a very meritorious case. Our case for bail was very strong and carried a lot of merits. We saw no reason under law or the facts of the case why the Learned Justice denied the application. It didn't make sense to us. On the 26th of February, when I moved this application in my capacity as a Nnamdi Kanu's lead counsel, 26th of February, I moved this application over in court, and I insisted on a bench ruling because I had a feeling that this was simply a matter of considering what the Supreme Court had said, that Nnamdi Kanu is being on bail, and we adduced new evidence regarding his failing health, very serious health conditions that the Department of State Security cannot handle, and other extenuating circumstances in his favor. So based on all of that and other equities of the case, I urged my lord to make a bench ruling. She insisted she wanted to write her ruling, and she suggested that the written judgment is going to be voluminous. That she needed time, at least 3 weeks, to do that. That was why I cooperated. I relented when she adjourned the matter to 19th and 20th of March. So yesterday, when we came to court, we were surprised that she didn't write anything. She delivered an oral ruling, oral judgment. I mean, she was looking at a scrap of paper, but the ruling lasted just about under 2 minutes, suggesting she didn't write anything. If she wrote a judgment and the judgment order, it probably would have lasted up to an hour and a half to 2 hours for her to read all of that, in my experience. So I wonder what happened somewhere along the line, that a case that had a lot of merit suddenly was treated with such undue levity by the judge. The undue levity was evidenced in the brief minutes or whatever, the apparent fact that she didn't write anything. So she could have just, if she intended delivering a bench ruling or such a short ruling, she should have done that on 26th February. Could you
highlight some of the merits that you say this bill application you filed? Can you highlight some of the merits it has?
Sure, I'll do that. I did that indirectly, what I called the equities of the case. You recall on 15th February, 15th December last year.
Right.
Yeah, this matter had come up before the Supreme Court. Well, Mazen Namdekano lost the main appeal, which was that his extraordinary rendition constituted prosecutorial barrier. He lost that, but he won the argument on his bail, that whether the question before the Supreme Court was whether he jumped bail or not, and Supreme Court said he did it. As a matter of fact, the Supreme Court went as far as condemning the unwillingness of this same trial judge to consider the circumstances that led to Nnamdi Kanu's failure to appear in court back in 2017, and circumstances that led his flight, to his flight of safety out of Nigeria. And they went as far as, at page 20 of the judgment, to question the impartiality of the judge. They used the word, the impartiality of the judge is suspect. They condemned all of that. They condemned the warrant of arrest, or bench warrant that she issued, upon which the extraordinary rendition was granted. So this is a circumstance that is in Nnamdi Kanu's favor. Is in favor of granting him bail or restoring the former bail. The second one is his air condition. The general public may not know it, but a prisoner's or a Business air condition is a compelling circumstance that enables him to be granted bail. And of course, Section 35 of Nigerian Constitution guarantees everybody the right to bail. So these are the other secondary factors to be considered. So if you are not in good health, you are a notch above the crowd. Your case becomes stronger. And we have well-established paper trail of the poor health condition of Mazen Nnamdi Kanu that has defied every solution applied by the state security services health clinic. And we know very well that government health clinics are not the best in the world or best in Nigeria, not the top of one that is located at a glorified police cell or police detention center, otherwise known as DSS detention facility. So health is the overriding factor. There are other smaller factors in the case that you can find in the delay that has been occasioned in this very case since 2015 by the government's incessant amendment. If you recall, this case started in 2015 as treasonable felony. It changed dramatically in 2021 to terrorism-related offenses. So the government has been moving the goalpost, making it impossible to take trial in this matter. And at each given point, when we apply for bail or when we take a constitutional application that we're entitled to, they begin to argue accelerated trial. You want accelerated trial, but you amend your charges every 3, 4, 5, 6 months. There have been at least 11 to 12 amendments of charges since 2015. And cumulatively, Nnamdi Kanu has, by consequence of that, spent almost 5 years in prison and counting. Pre-trial detention. What is the life expectancy of the average African male? 56. He has had 5 of those years taken away from him without conviction. These are circumstances to be considered in granting such a person bail.
All right. Now, you again. Okay, go on.
Okay. Again, if you go beyond the legalities and bring in the real world arguments in favor of granting him bail, the insecurity in Southeast has been linked to his detention. Well, rightly or wrongly, true or false, I think there's an element of connection there. And we believe that granting him bail will break that connection and restore peace in Southeast. This is what is to be considered outside the courtroom. And my Lord was well aware of that. So I don't know why she was not persuaded by the hard legal evidence before her. She should have been persuaded by something like this, of which she can simply take judicial notice of and do the right thing.
Now, he has been in detention since 2021.
Yes.
And up until now, yesterday, he was denied his bail application. And as it stands now, this is March 2024, and the trial has not even started, right?
Yes.
So once the trial begins, can the federal government amend its charges, or are they always able to amend their charges because the trial has not fully commenced? Once it commences, will they have that ability to do that? Will they have the ability to do that?
Under Nigerian law, the government unfortunately has limited opportunity to amend charges. The only person that can stop government from doing this, the only people that can stop it are the judges. The law says they can amend. They can amend their charges before delivery of judgment. They can bring in charges. And they use this, they abuse it. And I gotta tell you the truth. They abuse the process by amending charges at will, at their whims and caprices. And it's very difficult for defense counsel and the suspects or defendants, because the goalpost is being moved. You are charged with treasonable felony and your lawyer is preparing to defend you on that. For several years, they turn around, remove treasonable felony entirely. It's not as if they left it intact and added new charges. They removed it and brought new charges, thereby rewiring the brain of the defendant and his counsel to begin a new avenue of begin to explore new legal windows or defending the new charges. It's very unfair on the society,
that's what I'm
on
saying.
the common man.
Once the trial commences, will the window be open for them to amend the charges?
That's what I'm saying. There's no limit.
There's no
only
limit.
The judges can stop it.
Wow.
Yeah, only the judge can. Before delivery of judgment, even after you have taken a plea, they can come back and say, oh, we forgot one charge, or we want to remove one and put the other. Only the judge can say, no, it's way too much. I'm not going to allow any more amendments in my courtroom. And they can even take appeal against the judge if they choose. So that's what is going on, and they are using it to their advantage. But they will turn around and accuse us of stalling. That is very disingenuous. If you amend the charge, it opens a new window, a new opportunity, or it exposes the defendant to new perils to his liberty and to his life. For instance, the treasonable felony carried a certain long prison term, maybe life imprisonment, but terrorism carries death penalty. So those things have to be considered when you bring in terrorism-related offenses. In that very event, you are subjecting our clients to a cruel and unusual situation. So we have to explore every defense available, including motions, constitutional motions or motions allowed under the Constitution, to examine the propriety of these charges. And when we do that, they say we are stalling. What are we stalling? That we cannot defend our clients? If you amend the charge, we accept the charge willy-nilly, even if the charge is defective or in error or is nonsensical. These are the defenses we have before plea can be taken, or even after plea has been taken. They are generally called notice of a preliminary objection. When we do that, they say, oh, the defense is stalling, we are filing motions. But you are amending charges.
Okay.
So it is our right to file motions when we amend charges to test the veracity or the priority or the legality of that very new charge.
Did you capture these concerns in your preliminary objections? Because in that preliminary objection, you prayed the court not to allow Kano's trial until certain conditions were met by the federal government. What conditions were you making reference to?
Well, in this very particular circumstance, we filed a preliminary objection pursuant to Section 36, Sub 6, Sub B and C. This section pertains to fair trial. That is, to break it down, B provides, that is 36, 6B, provides that the defendant is entitled to adequate facilities to prepare for his defense. And the other one, C, provides that the defendant is entitled to have counsel of his choice to defend him. Now, Nnamdi Kanu is being detained at the DSS facility. We don't have the Liban license, the freedom that a lawyer requires to consult with his client who is going into trial. Yes, they have secret listening devices installed in the little 10 by 10 interrogation room where we meet Nnamdi Kanu 2 hours on Mondays and Thursdays only.
Wow.
Yes, and then they have secret videographic and photographic devices installed in there. And there's another room attached to that very room where that the room is permanently shut. And it's, if you peek inside when they open the door, they have all kinds of gadgets there with 2-3 officers and the headphones over them. The moment we go in, they're rushing into that room and lock it. And then there's an officer sitting by the door. So we don't have the privacy that is required under Nigerian law between a lawyer and his client. Everybody knows about it. I don't have to be a lawyer to know that the communication between a lawyer and his clients is like communication between a wife and a husband. He's shielded from the public. So we cannot properly prepare him for his defense because they are listening to our conversations, strategies and everything, and they are taking pictures of us. So when we go there, we whisper to each other's ears, and sometimes we gesticulate and communicate in sign language and by pantomime. Yes, and we are not allowed writing devices like pens and paper. So that
you're not allowed to go in there with writing devices.
Yes, materials. Yes.
So how about your phones?
We cannot write. We are not allowed to go with our phones. Our phones are left away at the reception. And we are not allowed to take documents to him unless the document has been taken to somewhere in the facility we don't know. Maybe they are forensic department or whatever. They make copies. So he gets the document the same day or the day after. So if, for instance, I take legal documents to him to discuss with him, they take the documents from me, they take it away from me. So I meet with him for 30 minutes because my other colleagues are waiting to meet for him for 30 minutes each. So by the time I'm leaving, if the document is not back, I leave without discussing that legal document
with him.
So in this kind of circumstance, we are not going to be effective in launching his defense because our hands are tied behind our back. And the Supreme Court said that the criminal accusation and criminal defense should ensure that there is equality of arms. You know what that means? Equality of arms. So if the government wants to take your life away, they should not tie your hands back behind your back they don't have to leave your hands alone so you can defend yourself. If you lose fairly, fine, but never should you lose unfairly. That is the essence of Section 36, and that was the bone and the meat of our notice of preliminary objection, which my Lord also denied yesterday.
Wow. So it was part of the things that you captured in the bail application that you had initially filed?
Yes.
Mm. So what was our response to this particular concern that you raised? Because this is quite
fundamental.
Yes. Did she, particularly say anything about the fact that you don't have privacy with your clients, the documents that you bring to him for discussion are taken away from you? What did she say particularly about this?
Unfortunately, my Lord was perplexed yesterday because it looked like she sort of put herself in a position of helplessness. Because when she denied the application, I was like, then where do we go from here, my Lord? We have not prepared our client for trial. The record before you reflects that our preparing him for trial has met with a lot of interference, and we have physical evidence to prove it. So how can you say you want to proceed with trial under the circumstance, a trial that would be reversed on site by the Court of Appeal? And it might be a career-killing trial as well. So she was like, then where do we go from here? I was like, you tell us.
So she had delivered the judgment before you now had to put things in perspective for her to understand?
Well, of course, she delivered it. It was an oral judgment. She didn't read the judgment. And at some point, it appeared she wasn't very conversant with the application. So,
right.
Yeah, so she started asking me, what reliefs did I request on the application? I told my colleague to search out the application from our file that we carry into the court in a big portmanteau. While he was searching that, I was standing. So I went to my phone. It was an iPhone. I went to iCloud, and lo and behold, I got a copy, electronic copy of the application. So I started it really now and reading the release. And she was looking at me like she has never heard of it before. So when I got to a point, she realized that maybe she may have cited it, but I don't think she was too conversant with it. So she told me to stop. She said, anyway, I have denied the application.
Wow.
I cannot reverse myself. I'm functus official. Because, if a judge makes a ruling, that's it. The judge cannot reverse himself or herself. So she said, well, I can't reverse myself. You're going to have to go to appeal. Or you bring application for something else. But on this one, I have already delivered a ruling. Everything was looking surreal. People who came to court who are not lawyers were like, what the heck is going on here? Well, I felt sorry for the judiciary yesterday. It didn't look very good. I'm a lawyer. I believe in the judiciary. If I don't, I'll stop practicing law. But it shouldn't be this bad. It was terrible yesterday.
So where do you really go from here? Because this is like 3 years in detention. The trial has not even started. From your explanations, it does not even seem the defense lawyers are ready for the case. So where exactly do you go from here? Are you going to file an appeal?
Well, you're beginning to sound like my Lord yesterday, because she said something that sounded like your own. So it's like the chicken and the egg, which one came first? I told her, if the defense lawyers and the defendant are not ready for trial, it is the fault of the government. It's not our fault. If our client is put in a situation, in a custodial or non-custodial situation, where we have the free will to consult confidentially with him, I assure you we'll hit the ground running as far as trial is concerned. Our client is anxious to clear his name, and we share that anxiety with him. But when the government places stumbling blocks to trial and turns around to request accelerated trial, that is double whammy. That is disingenuous. That is, hurting someone twice. It's not our fault, but we are not going to take accelerated hearing for the heck of it. We have to ensure that all the constitutional requirements for fair trial are in place before we accept any trial. It's not a court martial. It's a court of law, equity, and justice.
Now, while this is ongoing, the legal aspect of this battle, are you privy to, a possible political resolution to this?
Yes, the matter came in open court yesterday.
Mm-hmm.
And my lord was open to it under Section 17 of the Federal High Court Act. Federal High Court judges have the power to recommend or direct that reconciliation be done in either a criminal or civil case. It's not limited to criminal cases. It's not limited to civil cases. It goes across the board. It applies across the board. So when it came to a point where the court was pervaded with this atmosphere of helplessness, it's like between the rock and a hard place, the devil and the blue sea. The court wants a trial. Our client wants a trial. Government wants a trial. All want accelerated trial, but the conditions for trial are not there. And our application to the court to create the conditions of trial was denied. So when my lord was throwing up her hands in the air, I said, well, my lord, if we have come to this point of helplessness, perhaps you may consider invoking your power under Section 17 of the Federal High Court Act. She's a bit familiar with that, and I told her that under that you can recommend political solution. He did not use the word political solution. He said reconciliation. Mm-hmm. You understand?
So what was her response to that?
Well, she said, I made it as an oral application.
Okay.
She said, well, I've had you. This is a court of record. Go and put the application in writing and bring. She didn't say, no, don't even come to my court with the application. So when she said, go and bring the application, it's almost like a court order as well, but we call it a direction, which is also compelling. So I will bring an application as she directed. Yes, a court can participate in the act of political solution, otherwise called reconciliation. That is what is called in law. Whether it's political solution or contractual disputes resolution or two men fighting and you make peace between them, is all the same. The law calls it reconciliation, and Federal High Court judges have the power to promote it. The law said to promote. So the law is not really an ask.
And by that only no me kunu si wene so na ni ai na eme di chiche ni ro akwụkwọ ona anugonu ya bi ụmụnna ndị kọwagasị n'iru akwụkwọ nke dị ka ibia bụ ka ife ole ka ikwu gbasata maka ya bụ ife na bụ n'ife anyị na-eme na dị unu ma drop like comment maka na ga na-etikwuru na update dịgasị iche iche kwuru na amara ebe a na-eje kwuru na amara oge mmiri ji wee na-eme gịnị wee baa opi ụgbọgọrọ ife anyị na-akpụ ya. So I get to different teas, different cookings, different updates n'iru akwụkwọ. Dịka ịnụ ya bụ ife drop like comment gị gbasata maka ifiche n'iru akwụkwọ dị ihe ndị a niile. Alright, thank you and thank you for joining us once again at Eastern News 24. Okay, messi and umunnem.